All right, hello everybody. It's Ed Rosenberg again, and this evening I'm with CJ from AmazonSellersLawyers.com. How are you, CJ?
I'm doing great. I'm doing great, Ed. Thank you for having me.
Okay, so CJ is a lawyer actually who specializes in Amazon sellers issues, and he's actually helped a few people in our group. So we thank you for that. Now, there's a lot of questions which I and many other sellers always wanted to ask a very qualified lawyer. So I made a list of some, so I'll go through some, and I know I may not get an exact yes or no answer, but just so we have a broader understanding of the issue. So is that okay?
It's great. It's great. I'll do my best.
Okay, great. A large company sent me an email that I'm not authorized to sell something. Do I have to take off the item?
The short answer is no, you don't. Generally, as long as you purchased any product, any piece of property in what the courts call the stream of commerce, you can buy it and you can then resell it. You don't have to be an authorized seller to sell a product. In fact, Dell Computers had a lot of issues with this a couple of years ago. One issue that may arise if you're selling a product with a warranty, some warranties are only valid if they're purchased from an authorized reseller. Others are not. So it would depend on product by product. You can absolutely sell them. If the product has a warranty that is dependent upon you being an authorized reseller, I would strongly suggest that you put in the description of the product that while the product is brand new and it's never been used, never been opened, the warranty may or may not be valid. But there's nothing at all to stop you from reselling something that you purchased in the stream of commerce.
Right. Okay, so that's good. Amazon lending. Now, Amazon from time to time, they offer sellers, primarily people who, I think only sellers that have FBA inventory, and they offer them pretty good loans at pretty good rates. The rates aren't great, but it's so easy and there's no sign-up fee, so many people take it. Now, a lot of times it's a large amount. So what happens if it's a $500,000 loan, which I owe them, and it gets suspended? Do you know if they can legally confiscate my inventory?
Okay, the first analysis would be to look at your borrowing contract, your loan contract. The Amazon lending has changed over time, so your contract would govern. There's a couple of things that are important. They're a little bit off the issue. One, a lot of people think that when they borrow money to purchase goods and they send the goods to FBA, that's their whole debt, and that if they're not selling the goods, they don't owe the money. They can just take the goods. That's not accurate. If you borrow the money and you buy goods that don't sell, you still owe that $500,000. I think people have to realize that, and those documents also incur personal liability, where you're not just indebted to the amount of the goods, you're indebted to every cent that you borrowed, whether you made good purchasing decisions or bad. The goods, depending on what they are, Amazon probably has what's called UCC1 files, which means the goods are also security for your loan. But again, their documents have changed over time. So for the particular client, I would look at their particular documents that they signed off on when they took that loan. But the major issue, if you're borrowing money, you're responsible for that money, whether or not you're successful on Amazon or not.
So you're saying if the company goes bankrupt, they can come after my house?
If you if the company goes bankrupt and you sign personally, they're still going to come after you and your home. Well, that takes a lot of steps. If it was a loan just made to a company, and I haven't seen that, all the loans I've seen have been with personal guarantees, then you're still responsible if the company goes bankrupt or not. If you file a personal bankruptcy, you'd be protected. They would be treated like any other creditor, and their debt would hopefully be wiped out when you worked your way through the bankruptcy system. But generally, you are personally on the hook. You bring up the house as sort of has some extra protections when it comes to a family home. Also, family homes are often owned not just by the husband, but also by the wife, and that garners some extra protections. But should they sue, then they get a judgment, and then they go to collect their judgment on that bad loan. They can certainly seize your private bank accounts. So you remain, everything that I've seen, you remain personally liable whether your products sell or not.
Wow. I mean, that'll probably be a nightmare publicity-wise for Amazon if they take away somebody's house. But you're saying technically they can do that.
Yes, yes, but there's a lot of steps. There's a lot of steps to get there. Amazon's loan, just like anybody else's loan, in order to get to your assets, they have to sue you. They have to win. That means they have to actually show the documents that you actually owe money you didn't pay. Then that gets reduced to a judgment. Then they have to try and enforce that judgment. And those loan documents, I think they put the venue or the place they have to sue you as Washington State, which means they'd have to get a judgment in Washington. And if you're in New York or Texas or Florida, they then would have to bring that judgment to your home state, then reduce it to a local judgment, and then try and seize your assets. And there's a lot of steps in between. I would suspect that as time goes on, Amazon is either going to send those out to collection agencies, sell off the bad debt, or if we see Amazon gets into multiple areas, expand themselves into a collections type department, which will then subject them to the collection laws that are set, by the federal government.
Mm-hmm. Okay, how about this one? So I got suspended. There are experts who can do it and are successful in getting me reinstated. Why would I ever need a lawyer to do this?
Because I'm better. There are some really good people who do Amazon suspensions, and I'm in touch with several of them. Probably every morning I have a telephone conversation with some of the top people in this field. And I'm not going to say anything bad about them. I can tell you that a couple of things that are different when you use a lawyer. One, whatever you tell a lawyer, whatever you tell me, you're protected by the attorney-client privilege. So if you were getting the goods in some way that you would not want anybody to know, and you tell a lawyer about it, that information is safe. Not only can I not use that for my own benefit, but I also can't be compelled to tell anybody what you tell me. Where if you go to who do know their stuff, the information you tell them is not necessarily protected. They can be compelled to reveal your private information, and they're not obligated to maintain the confidentiality. So when you use a lawyer, you have some additional benefits. I also think that when you use a lawyer, I think what you're doing is you're stepping up your game. That if the appeals don't work, the plan of actions don't work, and you have to escalate it, and they see that you have a law firm behind you, I think they take it a bit more seriously. And I think those are some of the other benefits that you get. Also, by using a lawyer, issues like with MAP pricing or antitrust or trademark violations or copyright violations, I don't think any of the non-lawyers can really handle that. A lot of my practice is dealing with people who sell goods who are then accused of trademark infringement or copyright infringement. And as an attorney, the first thing I do is I look at the copyright application. Look at what do they really have protected. And you'd be surprised at how often that there are mistakes and they don't actually have a proper copyright, or you're not violating it. And if you're not violating it, then we reach around and we talk to the lawyer on the other side who's working for 21st Century Fox or Cisco, whoever. We say, by the way, your trademark, your copyright is not appropriate. And you're now interfering with my client's ability to earn a living, and you're causing lost earnings damages. You've knocked us off a platform where you're now costing us $10,000 a week, $15,000 a week, and you're going to be responsible for that debt. And that argument is very effective because the big companies and even the mom and pops are afraid of liability. If they're wrong and I'm right, then they're responsible, and no one wants to put their own head on the chopping block. And we're very successful in getting those complaints withdrawn. I use Cisco as an example. I was able to convince Cisco to withdraw a complaint that they were probably right, but they were very concerned that they had all their ducks in a row, and they offered to withdraw. And that was a good victory against the giant company.
Yeah, because many times all we want them is to withdraw the complaint and they'll stop selling.
Exactly. We do that a lot with our clothing sellers. You withdraw, the damage to the Amazon account is much less. It still exists. Mm-hmm. And we also agree to stop selling the Superman t-shirt or the Batman t-shirt, and everyone goes on their happy ways.
But how can they be secure that I'm going to stop selling those t-shirts?
The big companies and the big trademarks and even the smaller shops now are monitoring you. And they're hiring firms that would call them brand integrity firms,
right,
who are watching to see who violates and when. So if you make that agreement, I would absolutely stick to it, because what then you're at risk for is them telling Amazon that you made an agreement and now you violated it, you're violating it again, and I don't think that would be helpful. Most sellers just want to keep selling.
Yeah.
So if we can get the complaint withdrawn, we get the selling privileges reinstated, that's what most people want. They'll go on to the next product.
Yeah, because I speak to 5 sellers a day who have 1,000 products, and one company decides that they're infringing, and all of a sudden they're gone, and they couldn't care less about that one item, but they care about their seller's account. So, yeah, I could definitely see that. Okay, that was great stuff. Okay, let's go on to the next one.
No, but I mean to interrupt you. What's also interesting is what's going on now is with Amazon now selling like their own T-shirts, for example, with the merchandise by Amazon, they are now violating trademarks, and in a way, they're getting placed in the same boat that a lot of us are.
But they're not going to kick themselves off.
Yes.
Okay, I'm accused of operating multiple accounts. This is untrue. Amazon is not budging. Can a lawyer help?
The answer is yes. A lawyer can help. One thing that the lawyer needs is the truth from the client. And the multiple accounts can happen from different ways. It used to happen very simply, where if you lived in a city and someone was knocked out from the same building selling similar products, you would lose your account as well, being accused of having multiple accounts. There's also scenarios that I've dealt with where 2 partners split up and they both opened up new accounts selling the same products from the same spreadsheet in the same geographic area and the same bank. And what you need to do as the attorney is really address all of those things and show that it's separate. In one recent case, one partner had purchased the interest from the other. He bought the name and the goodwill, and the partner that had exited opened an account on Amazon, and my client got knocked out. And we were successful in showing Amazon through the legal documents, through the buyout contract, that these were 2 distinct people, and we had the right to sell, and it was the other seller that should be knocked out of the box.
Is it ever possible to speak to Amazon, or it's everything via email?
I've heard people have spoken to them. I never have. I don't know if it's because I am a lawyer. I like to document everything anyway. But there are account managers that they are offering to provide for several $1,000s a year as some type of benefit. So my understanding is you can from time to time speak with somebody. I don't think it's a wise thing to do. If you do end up on the phone with somebody, I would suggest that then you follow it up with a very descriptive email of what was discussed, and it's generally by email.
Right. The problem with the account managers is they have as much pull to sell a performance as you and I do.
That's what I'm hearing also for, even though you're paying extra money, they're not very successful either, although it's another revenue generator for Jeff.
Right.
I'm hearing the same thing, that there's really no extra except an extra bill and another thing in your pocket.
Right. Exactly. Okay, how about this? Now, this is heartbreaking because I saw this in the forums, and I'm assuming not everyone's lying. This guy, he got suspended, and again, this is his story, and I don't know the person at all, and then it was 90 days. I think now they made it shorter for 30 days, and he thought that he had more time, and they disposed his goods to the tune of $3 million. Now, I guess no one in Amazon thought of picking up the phone and telling him. So, can a lawyer do something in this case? Do you have any recourse?
Let me address generally, and then I'll address the specific fact pattern. Generally, if you have goods at Amazon and you stop selling and your time runs out and they destroy your goods, under the language of your contract, you're out of luck. They have a right to destroy your goods and dispose of them in any way they see fit once that time expires. However, if you're talking about a substantial amount of goods that are worth a substantial amount of money, it's probably worth it to push forward, because they often take longer to dispose of the goods than what the agreement says. And $3 million worth of goods is a lot of stuff to destroy. I would reach out to legal right away, put in a claim that even though there was a contract violation, the time has expired, whatever goods are left for them to mitigate the damages, to lessen the damages, and start providing documentation. And they have to do that. If you haven't actually destroyed the goods, you can make them stop. And I also, you put the burden back on Amazon to say, basically, we don't think you really destroyed our goods. We want them back. And if you feel that if it's only a day or two late or a short time afterwards, it's a lot of product or a lot of value, it's probably worth pursuing it to find out when they were destroyed, where they were destroyed, how were they disposed of. Because when you talk about that kind of money, it's probably worth the investment to try and recoup some of your inventory. But it's balancing. If it's a minimal amount, it's probably not worth the cost of an attorney. If you're talking $3 million, if you recover 10% of it,
Yeah.
way ahead of the game. So I think it is worthwhile.
Yeah. UK shutdown. I've seen it a lot. Somebody wakes up, he's in business for 3 years, all of a sudden he can't log into his account. All his FBA inventory, he loses access, and then the clock starts ticking where he's going to begin losing. Can an attorney help in that situation?
Yeah, an attorney can help. An attorney can help by addressing the underlying suspension. We're seeing a lot of verification issues suddenly over the past couple of months. Dealing with seller performance there, dealing with legal staff in Washington. And I think we can. But again, it's very, very case specific. Mm-hmm. If there are kind of minor violations or a high velocity of minor violations, I think you have a better chance of being reinstated and recouping your product. If it's more serious infractions, it's a little bit more difficult in Europe. You're dealing with Amazon UK, and then there are the individual countries, and they also now have the unified accounts. So it's a little bit more complex. And in my experience, it's a bit more difficult there because it's just not as established as it is here in the States. But again, case by case specific. I think when a seller contacts me, we don't charge for the initial consultation. We don't charge for a real brief analysis. And then we tell our clients, we're very confident we can help you. We're semi-confident, or we really think it's a shot in the dark. This is what it's going to cost, and now you can make a business decision whether or not you want to get us involved. And I think you need the information from somebody to tell you whether or not it's worthwhile to pursue. The UK is definitely more difficult than the US, but you're not dead in the water, depending on the facts of your particular case.
Right. Okay, how about this? Amazon accused me of counterfeit. They are wrong. They closed my account and confiscated my inventory. What recourse do I have, if any?
All right, let me split it into two things. The confiscation and getting reinstated. The contract with Amazon is absolutely awful, and they reserve the right to shut you down for any reason. So if you're dealing with counterfeit, inauthentic, those type of issues, you need to right away start gathering your receipts of where you purchased the items to show that they are, in fact, authentic, and address those issues like a normal plan of action, a normal appeal, to show them that these are, in fact, authentic items. Whether you can show they're authentic or not, Amazon, while they seem like they own the entire planet and they seem like they are the law, they're not. And they're not the final arbiter of what is authentic and what is not, and your goods should be, at the very least, returned to you. So there are two separate issues there.
Right. Okay, CJ, so we covered a lot, and I really appreciate it. We have a lot more questions, and I hope you can do this again. But thank you so much for answering. That was a fantastic conversation. I really, really appreciate it.
Thank you very much for having me.
Okay, thank you. Bye.